afternoon and welcome to our WebEx session, COVID-19, Renegotiating Private Equity and M&A Yields, Impact of MAC Laws. The session will be presented by my colleague, Mr. Vaibhav Parikh, Mr. Nishchal Joshipura, Ms. Simone Reis, and Mr. Parag Srivastava. Please note that this session will be in the listen-only mode and will last for about 60 minutes, of which first 40 to 30 minutes will be spent on panel discussion and the remaining time will be available for Q&A. Requesting all the participants to be on the mute mode for the session. You can post your questions in the chat window while the panel discussion is on. The moderator will keep the questions for the speakers accordingly. Should you need any assistance during the conference call, you can use the chat box. Do note that this conference is being recorded. I now welcome our session presenter, Mr. Vaibhav Parikh, lead TMT practice, also heads our US operations based out of our New York office. Our analysts for the day are Mr. Nishchal Joshipura, specializes advising private equity funds and strategic acquiral on controlled transactions. Ms. Simone Reis, co-head of mergers and acquisition and private equity practice. Parag Srivastava, also leader of M&A and private equity practice.
Thank you, Carlette. Good morning, good afternoon, good evening to everyone, wherever you are there. Welcome to our cCep program. We live in unprecedented times. A lot of people are going through a tremendous period of uncertainty. We don't know when this COVID-19 lockdown is going to end. We don't know when things will become normal or whether this is a new normal. So we are living in a situation where we have to plan our day every single day, take stock, and then to try to figure out how things are going to go further. And in this uncertain time when we don't even know how this will create an impact on economy, whether it's going to be a short term, so things will become normal soon, or whether this is going to be a long term and the economic impact will really last for a long time. We have to still make decisions based on what information we have, what we think the best, and we still have to go ahead and do what we think is going to be long-term good for our companies, our businesses, etc. In that scenario, when we look at private equity and M&A, that brings an additional uncertainty. The question comes in the eyes of private equity. What do we do? Do we invest? Do we not invest? If we are already negotiating, do we actually change our negotiation technique? Should we delay the whole thing? If we already signed up and waiting for closing, what will be the impact? If we have already closed, then what should I do? So there are various things in the mind of acquirers, private equity, or the companies which have taken private equity money or acquired on impact of this particular situation, not just on their business, but also on the investment or on the acquisition which has recently happened or is in process of happening. We also see that there is a lot of. We also see that there will be silver lining. The whole industry will change. New sectors will come up for investment. Some of the sectors will face challenging time for some period of time. To see from positive perspective, I do see, I was chatting with a few people, and I do see that there are some industry which will become a little bit, more attractive. A lot of people would have seen that, companies like Zoom has grown 300% in the last 3 weeks, right? Similarly, so industry like communication, 5G, industry or technologies relating around 5G, industry technologies relating around digital marketing, with respect to healthcare, hospitals, hospital management, medtech, edtech, because a lot of education now will become online, and there will be a lot of focus on online education. If you look at e-commerce, logistics, because there will be a lot of, it will change the way a lot of people look at how they live and how they do business. And they will incorporate a lot of things which is more of remote. So, working from home, remote management companies, software companies, because now they will actually be quite busy doing a lot of things which speeds up remote management and working from home concept. So we see a lot of new interest in the industry. Now, having said it, I thought it will be useful to go and check on certain implications of existing clauses, what we already have in the agreement, and try to see how will this pan out during this particular area. So my first question really is to Simone. Simone, can you tell, with this uncertainty going on, how will the MAC provision really be looked in light of COVID-19?
Thanks, Vaibhav, and I hope I'm audible. But let's just talk about what a MAC provision really is. It's the full form of it is material adverse change, and I'm going to sort of stress on the word change because it really depends on when you've entered into your contract to determine whether or not an event has occurred that results in a change from the time that you executed it till the date that you close. Now, MAC typically is a clause that allows an acquirer to have an out if an event occurs that affects the target business negatively. So assume today you've signed a contract assuming a certain revenue stream, a certain EBITDA margin, a certain sort of profit, or a certain sort of way the company runs. And if an event has occurred after you've signed that agreement, and that affects the company negatively, you could call that a MAC, and therefore the acquirer could have an out. But the standard for calling a MAC is not a low one. It's quite a high standard. In fact, it was only, I think, in 2018 that the Delaware courts finally sort of agreed on one transaction, on one acquirer being entitled to call a MAC and have that out under the agreement. So it's not a low threshold. And typically, if you look at the MAC clause, let's look at how it's drafted. It is drafted as an event or a change that is or could be expected to materially adversely affect the business, financial condition, prospects, assets, liabilities, results of operations of a target. But the typical MAC clause also excludes within its purview any changes that occur as a result of the general economic situation that do not affect the target business disproportionately from that of its peers. So in a situation today, there are two real limbs that have to be tested. One is, has that event occurred that really materially adversely has affected the business and financial conditions of the target? And two, has it affected the target sort of disproportionately to its other peers? Now, the devil really lies in the detail of the drafting, because a MAC clause, unlike, for instance, typical frustration clauses that are allowed under the Contract Act, a MAC clause is really something that has been agreed to under the contract, and it is a contractual provision agreed between two parties. And therefore, how you define a MAC clause becomes very important. Because, for instance, let's assume today there was a deal for the acquisition of an NBFC. Now, an NBFC today, who would you think the NBFC peers were? Is it other NBFCs? Is it other NBFCs that have similar exposures? For instance, if the NBFC that you were acquiring or wanting to acquire only had an exposure to real estate versus other NBFCs that had, a decent exposure to other sectors that weren't really affected by such a pandemic, would a MAC be triggered if you were acquiring one NBFC versus another? So in simple terms, the devil lies in the detail. But it's safe to say that the standard is really very high, and we've been asked a lot by our clients, acquirers, seeing one, whether their MAC clauses get triggered. Secondly, to make a decision whether or not to acquire, to call a MAC is also a very sort of a tall decision, one way or the other, because you have the liability of also being sued for not concluding your contract. And sellers also are concerned sometimes that their representations and warranties may not really be true, because as of execution date, you didn't really know, the reps and warranties that you gave as of the execution date may not necessarily be true as of the closing date. So there are various people looking at these MAC clauses to see how the deal should be consummated. Now, in addition to just target business MACs, you also have market MACs. For instance, if the stock markets are imposing embargoes, imposing trading restrictions, there is so much volatility, can especially a public market deal be called off as a result of a market MAC? So that is something that you need to look at. The next bit is on the acquirer MAC. So some clauses, some contracts have actually, drafted acquirer MACs, which means that if the acquirer is dependent on financing for the transaction and the acquirer is unable to get financing, can the acquirer say, look, the business has not suffered, but I, as the acquirer, I'm unable to finance this deal, and therefore I can call an out. So the MAC really is something in terms of how it has been negotiated and contractually. In terms of protection under law, our clients have been asking is that, we thought that the closing would happen immediately. They weren't really large CPs, and we've not negotiated a MAC clause. Can we take protection under the Indian Contract Act and ask for suspension of our obligations to invest? Now, unfortunately, the Indian Contract Act only provides for frustration of the contract. So if the contract, for instance, has become frustrated, it has become impossible to perform that deal, then yes, perhaps you could look to the Indian Contract Act to provide some relief. But mere suspension of or elongating the long stop date, elongating your obligation to acquire, you may not have that benefit directly under the Indian Contract Act. You need to look at how you contractually agreed to this clause in the contract that you sort of entered into. So the net result really, Vaibhav, is if you look at COVID-19 today, and the clause that everyone's asking is, will COVID-19 be treated as a MAC event? And let's break this down into sort of three situations, right? Maybe a situation where you had executed a deal in December. Second is maybe you executed a deal now in the last 2 weeks, and you're looking to execute a deal maybe in the near future. Now, I mentioned in the beginning that, MAC really deals with the word change. Now, if you had entered into a deal in December, perhaps you could say that the position has actually changed from how you looked at the world in December, and therefore, whether or not COVID-19 has an impact on your deal is something that you could really look at, because it is a change in the situation from where you last when you executed the deal. If you've executed a deal in the last 2 weeks, perhaps you would not have the same luxury, because the COVID-19 consequences were perhaps known to you at that point in time. If you are executing a deal right now and you don't have a specific consequence for COVID-19 situations, then the likelihood is you may not really be able to say that COVID-19 really is a change. But even if you've executed a deal in December, it's too early to tell whether COVID-19 would really have an impact on any deal, because, like I said, the standard is really high. The consequences today are consequences that we have limited knowledge of, because we don't really know when this is going to turn around. We don't really know whether there's going to be a bumper. There's going to be a vaccine, for instance, where these matters become redundant in the near future. What the consequence really is, whether there's really going to be a large enough impact in revenue, so we don't really know. And secondly, I think also given the fact that this is one of the first times that at least this generation has seen a pandemic that affects the world at large. It's affecting everyone. Perhaps it could also fall within the exclusions of a typical MAC clause, and therefore you may not be able to call a MAC despite the fact that you've entered into a deal in December. So some substances, COVID-19 is a circumstantial test. We need to look at clauses, but people are looking at their agreements once again to see what the impact would really be on their deals.
I just wanted to add one point on MAC, and this is related to MAC in case of listed company acquisitions. So as all of us know, there is a concept of withdrawal of open offer in case of listed companies. And we'll just discuss a couple of case laws under the 1997 Takeover Code and how things have changed in 2011 Takeover Code. So in 1997 Takeover Code, as you may be aware, there was Regulation 27(1), which talked about situations in which open offer can be withdrawn by the acquirer. And the three situations which were given were, one was if the acquirer, being the natural person, is dead, and hence it is impossible to perform the contract. The second situation was if the regulatory approvals which were applied for, the regulator has refused those approvals, and hence again it's a legal impossibility to perform the contract. And the third situation was where the acquirer can approach SEBI, and if SEBI feels that based on merits the open offer can be withdrawn, then SEBI can grant permission for withdrawal of the open offer. Now, what had happened under 1997 Code, and this is also relevant from a MAC perspective, because in case of Nirma Industries, Nirma had launched an open offer for acquiring shares of one of the companies, listed companies. And what happened was, during the offer period, that is after the launch of open offer, but before the consummation of the transaction, there was a fraud detected in the target company to the extent of 350 crores Indian rupees. Based on the fraud, Nirma approached SEBI and asked for exemption from making the open offer, and Nirma basically mentioned that it is impossible for us to now consummate the open offer given the fraud which has been detected now. What the matter went up to Supreme Court level, and what Supreme Court said is that we have to follow the rule of ejusdem generis, which means SEBI can grant approval only for the withdrawal of open offer only if the circumstances are the same as provided under the previous exemptions, which means in both the exemptions, one is when the natural person is dead, and in the second situation, if the statutory approvals are not received. both are natural impossibility and legal impossibility for performance of contract. And only in those situations, the open offer should be allowed to be withdrawn. What SEBI said is that just because fraud has been detected, it does not make the contract impossible to perform. And hence, as far as public shareholders are concerned, you will still have to make an open offer. And we will, and SEBI is right in not allowing the acquirer in withdrawing the open offer. So this was one case. There was a second case of Pramod Jain versus SEBI, where SEBI actually took almost 2 years to approve the open offer. And what the acquirer said is that 2 years is a very long period of time, and the financials of the company have changed, and hence you should allow us to withdraw the open offer. The same outcome from Supreme Court, that just because 2 years have lapsed, it does not make the contract impossible to perform, and hence you should still go ahead and launch the open offer. Now, this was the situation under 1997 code. Then in 2011, when the new takeover code came, there was a discussion within the members of, amongst the member of track committee, to allow something more than what is there under 1997 code. And hence regulation 23(1)(c) was introduced, where if any of the condition precedent was not possible to perform on account of it being outside the reasonable control of the acquirer, then it was possible to withdraw the open offer. So everybody actually thought that, you know, this has substantially relaxed the requirement under 1997 code. But what happened was, in a case of Jyoti Limited, under 2011 takeover regulations, there was a situation. Jyoti Limited, which is a target company, actually announced that it has become a sick company and it needs to make filings with BIFR. So it went ahead and did those filings, and BIFR said that there can't be any change in control without our approval. So this actually frustrated the acquirer, because the entire BIFR process was very, very long. And because the process was very long, the acquirer approached SEBI that under regulation 23(1)(c) allow me to withdraw the open offer. Everybody thought that this should be different from 97 code. But again, the way SEBI reacted, SEBI said that circumstances under 23(1)(c) should mean the circumstances as have been interpreted by Supreme Court in the previous two cases under 1997 code. And hence, the mere fact that the company has approached BIFR and you need an approval from BIFR for change in control, and that approval is taking a long time, is not a right reason for allowing you to withdraw the open offer. So broadly, things haven't changed as far as this concept is concerned. We'll need to wait for some more jurisprudence on this, since this was just a SEBI order. But it's important to understand that the threshold for withdrawal of open offer, which I would say a MAC for open offer, is much higher than the threshold for MAC for a primary transaction. So you may be able to prove a MAC vis-a-vis the primary transaction where you're buying controlling stake from a promoter. But the threshold for MAC for buying shares from the public shareholder is very, very high, and you have to prove that it is impossible to do that transaction. And that's where SEBI may be able to allow the acquirer to withdraw the open offer. Sorry, Vaibhav, for the interruption.
Yeah, thank you, Nishchal. Thank you, Simone. What I understand from Simone is that for private company at least, what is written will matter a lot. There have been clauses I have seen where a slowdown in industry is not considered to be MAC, and there have been clauses where I have seen that particular thing to be absent. So it will be interesting to see how the companies look at this, and how the jurisprudence courts look at this, if at all it comes into picture. But now let's move on to another question for Simone. Simone, this is likely to delay the closing. You know, if you already signed up and you're waiting for certain things to happen, it's possible that the closing may delay because condition precedents may not be met, regulatory approval may not happen, how this is going to affect the stencil operations, right? Because generally there is a provision between signing and closing that company will only work in an ordinary course of business. So how this is going to affect the stencil provision? Can you expound on that?
Well, I'll be brief, but you're right. I mean, you enter into a transaction document today, thinking that things are going to go on as usual, and therefore you use the word ordinary course between the date of execution and the date of closing. But the reality is, these times are anything but ordinary course business. In fact, you have to take extraordinary measures to actually survive, and therefore the standstill provisions really will have to be looked at very carefully. How will the company really be in breach of your obligation of a standstill provision in these times? And let's give a sort of a quick example, right? What's happening with respect to the stock markets now? Many companies today have even given or promoters have actually pledged their shares to banks, and margin calls are being made. There is stress with respect to the security value, and therefore there could be situations where for no reason there could be really an event of default that is called by lender. So that's one concern. How do you deal with that? The second issue is really you may need quick liquidity into the company. For instance, there have been so many companies that are unable to, manufacturing has been stalled, restaurants operations have been stopped. So there are many sort of companies where you would need immediate liquidity, and therefore the ability to seek acquire consent to actually get in a drawdown funds may not necessarily be, you may not really have the time to do that. So that's sort of secondary. So various things that you would otherwise take for granted in terms of standstill are things that will have to be looked at carefully in terms of how the agreement is really worded and what protections the seller and the company really has. Because at the end of the day, what needs to be done to keep the company afloat is actually paramount.
So Parag, next question is, given the situation where we are in, how do you see the condition precedents in M&A transactions and PE buyout transactions shaping up going forward? And what do you think would be the relevance of some of these CPs, and how are the parties going to decide on the long stop date going forward?
Thank you, Nishchal. So, in terms of CPs, as so what basically condition precedents or CPs, as we call them, are certain conditions that have to be fulfilled by the target company before, acquirer completes the transaction. Now, how these CPs are put into the documents is primarily a result of the due diligence that has been undertaken on the target, right? And the kind of issues, whether, from a commercial or legal perspective, that have been identified by the acquirer are then included as a CP. And CPs can be of various types, from various consents, approvals, from regulators, lenders, counterparties, or rectifying certain issues or non-compliances that the company has currently. So before the CPs are negotiated, it may also be worthwhile to just take a relook at the diligence, depending on where you are. If you are still conducting the diligence, then obviously you can ask for additional data and analyze it. But in case the diligence is completed, the acquirer may want to relook at the documents that have been provided, because the scope of or the conditions on which you are conducting the diligence has changed, right? So maybe initially you are only looking for a while reviewing a contract, a material contract, that whether there are any consent requirements or not, right? You typically note that there may be a force majeure clause, but you don't really pay attention to it because conditions are not there. There's nothing known at that point of time, right? But here, after this situation, we may need to look at those contracts and see if any conditions have to be added from that perspective. Secondly, another impact of this whole situation which will have on the conditions to be satisfied are the how the regulatory bodies are functioning. So if we in the last couple of days, the Competition Commission of India and the NCLT have really limited their operations, right? So wherever the transactions require approval of any regulator, and in the limited functioning of these regulators, the parties may need to think about the timelines. And see, currently it's a short term suspension. It's only till 31st March, but there is a possibility if the situation continues, it may go on for some time, right? So what do parties do where a CCI approval is required, but CCI is not functioning? There's no pre-consultation that is happening, or all the filings have been suspended. Parties will need to think about these conditions. Plus, also from a perspective of the lender consents, as Simone mentioned, the things may change, between signing and closing. So accordingly, the lenders will also look at the solvency issues at the target, and what value add acquirer will bring in a new light, looking at these situation. Another thing, that probably will play an important role here is structuring, because it may be required, depending on how long this goes on, that, while the structure may need to be revised or re-looked into, to avoid as many regulatory approvals, that are required, though there may be a hit from a transaction perspective or a tax perspective. Not transactions, actually more from a tax perspective. So for example, where the parties have gone for a demerger approval, but because NCLTs are not functioning, they may need to look at and do an asset sale or a slump sale, in order to consummate the transaction. Now, from a Webunar, you also asked me about the long stop date perspective. So, I believe that long stop date is something that will need to be looked at from a transaction to transaction perspective, right? Because as you initially mentioned, different industries are being impacted in a different way because of this COVID-19, right? So, industries where there's a significant impact on the operations, from a seller perspective, they would definitely want to elongate the long stop date so that things become normal, and the transaction can go through. From an acquirer perspective, they may be looking at it from a very different perspective, because they may not want to wait for that long, because till things become certain. In other industries which are not significantly impacted, probably people will wait for a certain amount of time, and then if there is not much impact today, and nothing happens in this interim period, then they can probably go ahead and close the transaction. A long stop date also becomes relevant from the regulatory approval perspective, because in the absence of what is going to happen with the functioning of the regulators, parties will need to see whether long stop dates, though there's always a flexibility in the document to extend the long stop date if both the parties believe. So it's also the commercial synergies between the parties, and whether how the acquirer is still looking at the target, looking at considering the situation today, will be relevant. One more thing, because and I would just take a step back to the conditions precedent, right? While we always identify specific conditions and put it in the documents to be satisfied, we may need to look into including some broad language to say that parties may negotiate the additional CPs if any new conditions arise between now and between a certain date, between the long stop date, in order to satisfy that.
Okay. So I was asking Nishchal, in this era, right, how will reps and warranties be negotiated separately? Is it something which is going to have a private equity or acquirer relook at reps and warranties when they negotiate in future?
Sure. So I think all depends on for how long COVID continues, and the longer it continues, the impact is going to be more. And if the impact is more, then my view is that the seller friendly or a seller friendly market could turn out to a buyer-friendly market. And if it becomes a buyer-friendly market, then we are going to see a huge change as far as the negotiation of reps and warranties and indemnity will happen going forward. So just to give you an example, you know, uh, currently the deals that we have been doing, there is somewhere there is a degree of trust which the buyers have in the sellers. But with COVID happening, and if, as I mentioned, if it prolongs, then there will be a substantial and significant dent in the trust which the buyers have on the sellers, and that's going to impact the negotiation. So just to give you a few examples, currently when the indemnity and the warranty package is worked out, one thing which, especially when a private equity control buyer is selling stake in an Indian company, one thing which the buyer is sometimes okay with is that the seller entity is a fund, and as far as the business warranties are concerned, warranties are going to get over in next 18 to 24 months. Until that time, the fund is going to be alive, so there should not be any problem. What might happen going forward post COVID is that the buyers might insist on a number of protections from the selling PE fund, and not just limited to whether the selling PE fund is alive or not. Some of the buyers may also trigger LP clawback or LP giveback clause, that if the warranty period expires but there is a claim beyond the fund life, then we may want to look at how that claim is going to be satisfied by the fund, and whether there are any provisions in the fund documents with respect to LP giveback. So this could be one of the things which might happen if COVID turns out to be more draconian than what it is today. The second important change that could come is in the current M&A PE buyout deals, 15 to 25% is the range that we are seeing as far as the cap on business indemnities is concerned, basically indemnities for breach of business warranties. That cap, in very, very exceptional situations, this cap we have seen going up to 50%. But if again COVID becomes more drastic and things go out of control, then I won't be surprised if this limit gets increased to 50% and above, because the buyers may want full protection for any downside which might happen on account of COVID and its related implications. The third important impact could be on the time period for the business warranties, which typically in India the standard is 18 to 24 months, and in exceptional situation we have also seen 36 months from the date of closing. That might change from 18 to 24 to maybe 36 months, because the buyer may want protection for a longer period of time to ensure that the period of for stabilization of the company is covered as far as the period of indemnity and warranty is concerned. The other change which we might see is currently from a seller's perspective, there are knowledge qualifiers which are incorporated in the warranty schedule. That's something which, in my view, might change post-COVID. Especially for warranties on litigations and investigations, or licenses or approvals. I think these are 3 or 4 major heads where the buyer will not be comfortable going forward to allow seller to have knowledge qualifiers. Another important point which might come up is on the defense process. Typically, because the ultimate liability for indemnity is on the seller typically want to control the defense process in case there is a third-party claim which comes out. However, going forward, what might happen, especially in controlled transactions, the buyer may want to may want to front the claim process to ensure that any third-party claim is well defended, and there is no liability which comes on the company. Because if the liability comes on the company, and ultimately even if the seller has to indemnify, if the seller himself or itself is not having sufficient financial wherewithal to honor the obligation, then the buyer may want to take control of some of those claims. Another important point, which is something, is the warranty and indemnity insurance, which has become a very popular product in the last few years, especially for the sellers, since they can pretty much be off the hook as far as the indemnity is concerned. There, what we see is, and we hope that this product continues, but if on account of COVID, if the global insurance companies take a view that India has become a high-risk jurisdiction, then in that situation, what might happen is, the premiums may increase from 1.5 to 2.5%, which is the current rate, and it could be higher also. And as I mentioned, this is all we are comparing the current market with the market that could be because of COVID. And while some of these are very deal specific, but overall, if it becomes a buyer-friendly market, then some of the standards are going to change going forward. We may also see from a tax indemnity perspective, especially the withholding tax, given that India as a country is going to face pressure there will be a lot of pressure on the tax exchequer. We might see the Indian tax department becoming more aggressive going forward for collecting taxes, especially for large transactions where the foreign investor is exiting from India. In those situations, the question which will come up is whether tax indemnity is a sufficient recourse for the buyer, tax indemnity from seller is a sufficient recourse for the buyer, or would the buyer insist that the seller should get a nil withholding order from the tax department, especially for transactions where the seller had purchased shares of the Indian company prior to 31st March 2017 when the treaty benefits were available. So broadly, as far as the warranties are concerned, these are the changes which we might see. Of course, nobody knows to what extent these changes will happen. It all depends on how COVID shapes up going forward. But at least the world is not going to be the same as far as some of these negotiations are concerned going forward.
Thank you, Nishchal. Keeping time in mind, can you spend 2 minutes on downside protection?
Sure.
And see how this is going to pan out?
Yeah, I think so. What I spoke about was on warranties and indemnity, but just like what happened, after the Lehman crisis in 2008, and just to give you a comparison, before 2008, number of LPs were very hands-off as far as their investments in India were concerned, and they were completely relying on GPs. But what we saw is from 2008 to 2012-13, there were not many exits which happened from India, and there were a number of disputes which happened between private equity funds and the promoters. So what the LPs started doing post the global financial crisis in 2008 was they started taking more operating role and started getting more involved in the GP and in the portfolio companies of the fund. I see a similar wave coming back 6 months down the line once the COVID issue gets over, where the LPs may want more protection for the deals that they are doing through the GP. So they may want more of operational result matters compared to what they have today. There could be a more negotiation on drag clauses vis-a-vis the promoter, which currently some of them are okay to let go. So there is one question: what is LP and GP? LP is a limited partner who is the investor in the fund, and GP is like the manager. GP is a general partner. LP, GP are US terms. The equivalent in India are investor and manager. One more thing that we will see going forward is funds willing to participate more in board meetings and in the committees, especially the operational committee, the human resource committees, the business the operating committee. So some of those committees will see more involvement from the acquirers and the private equity funds. We will also see tighter event of default clauses going forward, where currently the event of default clauses more or less is negotiated where something drastic has happened in the form of malafide intent of the promoter to take decision on certain matter without consulting the private equity investor, or if there is a fraud by the promoter. But we might see this list prolonging to beyond just the malafide intent, to ensure that the buyers or the PE funds are completely protected from any downside which could happen going forward. So broadly, these are the downside protection, Vaibhav, I feel will become much tighter going forward.
Thank you, Nishchal. Let me just spend 2 minutes on impact on valuation, because I was chatting with a private equity friend of mine, and I was asking him, how it's going to affect him. And his first question was, I don't even know how do I value the company, because I don't know how long this is going to last. I don't know what's going to be impact on the industry, how long the impact is going to be there. And that raised a question saying that, hey, how the valuation is going to work, especially in India. And what at least we think will happen now is the valuation will not be the standard valuation what we see. There will be a lot more convertible instruments being used, where the valuation may be determined in a later date, especially once the impact of COVID-19 is kind of given out, because it is likely that the private equity may want to have a lower valuation, may think a worst case scenario. It is likely that the founder or the promoter may want to have a lot more optimistic and not willing to agree to a very bad scenario. And since nobody knows on the impact, it is likely that there will be some mechanism which will be put in where the value can be reassessed. Similarly, in acquisition, there will be many earn-out concepts coming up here, because, again, for same reason, if there's an acquisition and if the valuation becomes a debatable point, then you will see earn-outs which will come in, which says that, hey, if the COVID-19 does not impact the operations of the company to the extent one party thinks so, we will use earn-out to compensate the promoters so that they can benefit of higher valuation because the impact was not so high. In other words, I think there will be some uncertainty for at least next year or so, maybe 2 years, depending on how long it lasts. And because of uncertainty, there will be very creative valuation concepts which will come in, which will determine valuation based on how the economy picks up, how the company reacts to the new situation, and so on and so forth. I think with this take, we have about 10 minutes left, and why don't we leave it, open it to question and answers. Nishchal, do you want to take the demerger question which is there on the screen, on the chat screen, and see if there are any other questions coming in?
Sure. I think the question is, in case where a demerger scheme for transfer of undertaking from company 1 to company 2 is filed with NCLT on day 1, can the company 1 enter into an agreement to sell the same business to company 2 on day 30, stating that such agreement to be subject to demerger scheme not being approved by day 120? This agreement to sell, once effective, should result into all assets and liabilities pertaining to the business to be transferred to company 2 from day 30, whereas the actual transfer of business may take place on day 120. So just trying to understand the question better, I think what the point you're making is, if there is any uncertainty of the demerger scheme going through, can we enter into an agreement to sell on day 30? And as per that agreement, the business will get this agreement to sell once effective should result in all assets and liabilities pertaining to business to be transferred from day 30. Okay, so I think based on what I understand from your question, we cannot have two parallel agreements, one for demerger where you are anyways transferring the business as part of the demerger, and you would have taken approval also from the shareholders and the creditors for the purpose of doing the demerger and filing the scheme with NCLT. So parallelly doing another structure which also contemplates the same business transfer is something that will be difficult from a shareholder and creditors perspective, because you need to be clear on which path you are following. If it is done after 120 days, so let's say you keep a long stop date of 120 days for the scheme to be approved, and if after 120 the scheme is not approved, and then by default you move at the end of 121st from the 121st day to a normal business transfer without a scheme, that's something that should work. But we can't have two parallel business transfer processes running as far as the approvals are concerned.
I think Ankit had asked question on please discuss the current WeWork situation. I'm not sure what question you're looking at, but if you're looking at a situation, what is happening in WeWork in the US and how this will affect, I think in my view, COVID-19 will make the operations of WeWork maybe even we don't know how the impact on COVID-19 will happen to WeWork on a longer period of time. On short term, they will get affected, and they are not going to see new customers or new renewals happening. So it is going to have operationally difficult. Now, what is mean for SoftBank and other investors? I think they will have to pump more money to keep it open. So I don't think in the situation we are looking at, the COVID itself will make that much difference other than the operations being difficult in the near term. There is another question. Michelle, you want to, or Simone, you want to take the question? I think question is about how about a situation where contract is inked and other parties acting tough? What are the things that I as an investor should do to mitigate my risk?
I think the devil lies in the detail, right? And we need to look at how the agreement is really worded. If there's a change in contract that has to be done, it requires both parties' cooperation. But that being said, there are practical ways of trying to get what it is you want to do, right? Because at the end of the day, no one really wants to go to litigation, right? It depends really on what the contract is. And therefore, if there's a particular fact pattern, we're happy to sort of discuss what you could do to mitigate your risks offline. But typically, it really depends on how the contract is worded and what the CPs really are.
Yeah, thank you. Nishchal, you want to take the next one on listed company, which is an NBFC?
Sorry, which one? I'm just looking at.
The question is.
Is a listed NBFC?
If the acquirer of a listed company is NBFC and had control related issues at RBI level, how does SEBI look at giving open offer approval? So I think if the approval is rejected by RBI, and as we know, more than 26% shareholding change in an NBFC requires approval of Reserve Bank of India. If that approval is rejected by RBI, then it will fall within the category of legal impossibility to perform the contract, and hence you don't even need to approach SEBI. It's something which is already covered in the regulations that open offer can be withdrawn if any statutory approval is refused. Okay, so the question is, acquirer is NBFC, target is a normal company and not NBFC. So if acquirer is NBFC and the question is, we need to understand what are the RBI level issues with the acquirer is facing. As such, the acquirer level issues, unless it is resulting in impossibility to perform, should not be the should not result in the withdrawal of open offer. It has to be.
Yeah, and Mr. It also depends on what sort of what you've declared in the open offer document, and where regulatory approvals have been set out. What have you said is a regulatory approval that is required? So typically, regulatory approval outs are there. If you require a regulatory approval to acquire something else, and if you clearly establish that in the open offer document, then I suppose you could take some recourse. But if that's not the case, and that's an internal problem, then like you said, Nishchal, you don't have that luxury of calling it out.
That's correct.
Yeah, and with respect to the WeWork 3 billion commitment, I think, look, there has been a commitment written. We don't have the fine print of the contract really, and depends on whether the 3 billion commitment, some of which has already been deployed, is linked. Again, the 3 billion was to cover losses. Now, you have a situation where you have even more losses, right? So it really depends on what the condition to the commitment really is. And since the primary sort of objective was to cover losses, I don't know whether 3 billion would be a question or whether they would require another 3 billion to actually make good the initial 3 billion. So.
Yeah, I agree with Simone on this. Lot will depend on that. I don't think at this point of time, considering the New York situation, also there will be the US situation. There will be a lot of thought on it. I think they will actually wait for some time to get a little more clarity before looking at this question. With this, thank you so much, everyone, for joining in. We really appreciate. Again. We hope to see you in other continuing education programs which we have.